Hello, hello. Welcome to Crime in Court. My name is Heather, and this is an update in the Delphi case. So, we're going to be talking today about Indiana versus Richard Allen, and that case is starting to get underway because we just started jury selection as of yesterday. So this episode is titled Wild Updates as Jury Selection Begins. So we have multiple motions that we have to get through. We still have two motions that we didn't do that dropped like Friday of last week from the defense. And then we have a couple motions from the state. They have a couple motions in limine, which are things that they want to exclude, and that is, they were just dropped today as of Tuesday, October 15th. Yesterday, the 14th, is when jury selection began. So let's get started. Please hit that like button for me if you don't mind. It really helps the algorithm. And thank you so much just for being here. I appreciate you for that. All right, so let's begin. We have a lot to get through. All right, so the defendant's motion to incorporate evidence represented at the August 1st pretrial hearing into offer of proof at trial. So this, again, like I said, we have two motions to go through from the defense. This is the first one. So we talked about this. We went over the transcript and read it all the way through for those days. The mini hearing that they had. It was like a 3-day hearing, and they went over many motions, their pretrial motions and whatnot. And this is they want the information that came up to be offered at proof uh, at trial, offer of proof at trial. All right, so comes now the accused, Richard Allen, by and through counsel, and respectfully asks this court to consider this motion regarding his offer of proof. In support of this motion, the accused submits the following. Number one, a hearing was held on several motions, including the state's motion in limine in this matter on July 30th through August 1st of this year. During those hearings, particularly those on July 30th and August 1st, testimony was taken regarding paragraph 7 of the state's motion, which argued that evidence of third party suspects and motive, including those practicing Norse paganism, Odinism, should be excluded from trial. So remember, Nick McClelland filed his motion to eliminate that said, I don't want the defense talking about basically anything. So and some of those things that were listed were talks of Odinism, the Norse paganism, religion. They don't want that. The state does not want that to come in at trial. Obviously, that is the defense's main defense, as they put out in their Frank's memo. So at this hearing, the defense presented its proposed evidence through certain exhibits as well as testimony of Dr. Dawn Perlmutter, who was excellent, by the way. And I believe it was on the August 1st, that the last day that we read through Dawn Perlmutter's testimony, and she was excellent. She talked about Norse paganism and Odinism and how, it's prevalent and it's out there, and it exists, but yet the state wants to pretend like Odinism doesn't even exist. So, anyways, so they want to present, at this hearing, the defense presented and proposed evidence through Dr. Dawn Perlmutter, Kevin Murphy, Todd Click, Amber Holder, Jerry Holman, Chris Cecil, and Patrick Cicero, among others, and argued that evidence should be used at trial to argue that third-party suspects committed the crimes and/or the homicides were likely involved in Norse paganism or Odinism, and that said testimony from all of those individuals and the evidence should therefore be admissible at trial. What do you guys think that Gull is going to do? Probably not likely to let it in, but we'll see. I mean, I don't know how she can not let in certain evidence, but I mean, it's her courtroom, so whatever. But it It doesn't make any sense to normal people why she's excluding all of this stuff or allowing it to be excluded. Number three, on September 4th, 2024, the court issued an order granting state's motion in limine and excluding evidence of third party motive, including evidence regarding Odinism, cult, or ritualistic KILings. Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Klein, Jerry Klein, and Ron Logan. So, as you may remember or recognize, all of those names are individuals who were other suspects or potential suspects, should be suspects. Number four, in its order excluding the evidence, the court noted that it will allow that evidence to support an offer of proof if one is made by counsel. Therefore, the defense does not believe it is necessary to make the request found in this motion, as the court has already stated that it will allow an aforementioned testimony and exhibits to be used as an offer of proof at the trial. Number five, the defense makes its request in this motion at hand to even further preserve the record that the court will allow the aforementioned testimony and exhibits to support an offer of proof that counsel for Richard Allen will be making at trial. So all of that stuff should be able to come in, everything that they talked about in those 3 days of their hearings. They want to be able to bring it in, the third party suspects and the Odinism. Number six, the defendant intends to make an offer of proof at trial regarding the evidence of third party suspects. Hold on, it's going to get loud. Sorry about that. The, my boyfriend's home and the dogs go running down the stairs and they're just super loud, and I'd rather not try to talk over them and hurt your ears, so it's better to pause. All right, so number six, the defendant intends to make an offer of proof at trial regarding the evidence of third party suspects' motive of the individuals listed in the listed above, as well as that of the third party suspects who took the lives of the victims were involved in Norse paganism, Odinism. Number seven, as an offer of proof, one must make the substance of the video, two, the grounds for admission, and three, the relevance of the evidence known to the trial court in the offer to prove. Number eight, the defendant submits that the substance of the defendant's proposed evidence has been made abundantly clear during the lengthy pretrial hearing regarding the issue, and therefore moves to incorporate the evidence presented at the pretrial hearing on January 30th and August 1st into the record at trial for purposes of the defendant's offer of proof. So basically, an offer of proof is like to show the judge that there's enough there to get into the topic. So he needs to show the nexus. He needs to show how these other people might be related to this case and um, how relevant this information is to the case. Because you can't just go around accusing anybody, but you need to be able to show, like, hey, there is this, there's reasonable belief that one might want to take a look down this road on this topic because there's something there. There's a there, if that makes sense. All right, so number nine, the defendant intends to make his formal offer of proof during the defendant's case in chief and present additional legal and factual arguments in support of the admissibility of the defendant's proposed evidence at that time. Number 10, however, should the court grant this request, as it has previously indicated that it would, the defendant intends to rely on the evidence presented at the pretrial hearing on those issues and not present any redundant evidence in the offer of proof. So they're saying we don't need to bring up Dawn Perlmutter and have her talk all through this again and do well, I don't know her specifically, but whoever, they don't need to bring in every single witness now and question them because they can bring in the testimony, and that will be part of the record. That'll be part of the evidence that that the jury would need to read. So they're saying we don't need to present the redundant stuff because if you let us get this in. So it's saving the court some time here. Number 11, granting this motion should serve the cause of judicial efficiency as the defendant's offer of proof would otherwise cause a significant delay in the trial if the defendant were required to present the same evidence in the record at trial. So, again, they're saving time. Furthermore, the granting of this motion before trial will also save money for the Carroll County taxpayers, as those witnesses who have been served with subpoenas will not need to appear, nor will they need to be paid the mileage to appear, including the cost of airfare and time for certain expert witnesses that would be especially costly. Wherefore, the accused, Richard Allen, by and through counsel, respectfully requests this court to incorporate the evidence presented at the hearing on the state's motion in limine held on July 30th and August 1st into the defendant's offer of proof at trial and for all other relief just and proper in the premises. So, yeah, there you go. That's signed by all three: Baldwin, Rosie, and Auger. All right. The next motion is a verified motion for certificate of appearance regarding out of state witnesses. So this is in regards to Dr. Walla. And there are major issues with Dr. Walla, if you recall. Well, first of all, Dr. Walla did come in to testify during that hearing, and we never got the transcript because it was asked for in FOIA requests, and people even paid for the transcripts, and yet they withheld the transcripts of Dr. Walla, and I think there was one other witness that they withheld. I'm not sure, but they withheld Dr. Walla's because of health discussions or whatever. But it's really, I think, it's a public record. It should have been released with the rest of the transcript. So why they withheld it is very curious. And Dr. Walla, it's problematic because she's the psychiatrist that, if you remember, was seeing Richard Allen in the Westville Correctional Facility, and she was also in Libby and Abby groups on Facebook, and like Justice for Libby and Abby and all that kind of stuff. So she's been kind of active in the online community speaking out about this. So there's issues with Dr. Walla. But that doesn't mean that they can't bring her in as a witness. So here is a verified motion for certificate of appearance regarding out-of-state witness. Comes now Bradley A. Rosie, counsel for defendant Richard M. Allen, pursuant to a bunch of codes, and respectfully request that this court issue a certificate of appearance under the seal of the court, directing material witness Dr. Monica Walla to appear and testify at the trial in this cause. In support of said motion, Attorney Rosie swears and affirms as follows. 1. The jury trial in this matter is set to commence on Monday, October 14th at 9 a.m., at which time jury selection will commence in Allen County, Indiana. By direction of the court, opening arguments will begin on Friday, October 18th. While awaiting trial, defendant Allen was detained for a period greater than 1 year in the Westville Correctional Facility Maximum Security Segregation Unit pursuant to a safekeeping order issued by the Honorable Judge Benjamin A. Diener on the 3rd day of November 2022. Pursuant to said order, remember, he didn't even have an attorney at the time. He was just transferred to this safekeeping order, basically transferred into solitary confinement for the whole time that he was there, which 15 days is going to start to give you severe, not severe, but at least 15 days of segregation can start to cause you to have mental health concerns. So while awaiting trial, defendant was detained for a period greater than 1 year at Westville Correctional Maximum Facility. Pursuant to said order, custody of defendant Allen was transferred to the Indiana Department of Corrections while defendant Allen awaited trial. While at that facility, defendant Allen was assigned to psychologist Dr. Monica Walla, who was at the time employed by IDOC's third party mental health provider Centurion. On or about July 31st of this year, Dr. Walla remained employed at Centurion and testified at pretrial hearings in this cause. In the days following her testimony, Dr. Walla was issued a gate disclosure by the Indiana Department of Corrections, and it is believed that Dr. Walla is no longer employed with Centurion. Meaning, okay, what happened? Was she fired? We need to know that. The defense just recently became aware of said gate disclosure and apparent termination of employment with Centurion. So it is an apparent termination in their words. Centurion's legal representative, attorney Robert Brandt, did communicate to attorney Rosie via email on September 18th of this year that he no longer represents Dr. Walla. So Dr. Walla lost her job and she lost her attorney. Her attorney no longer represents her because he was probably through Centurion. Yeah, he's the Centurion's legal representation. So he no longer represents Dr. Walla and cannot accept service for any subpoena or other documents directed to her. Attorney Brandt further represented that he no longer represents any other party or non party involved in this case and therefore cannot accept service on behalf of Centurion or any other Centurion provider. That's BS because she was employed by them and now they're just going to be like, nope, we let her go. Our hands are tied or our hands are clean. We wash our hands of her and it's not our problem, not Centurion's problem anymore. That's BS. They should be able to see, like, well, I know she's not represented anymore if she's no longer employed, but she was employed, and the legal team of Centurion should be part of this, I would think. Unless, I don't know. I would think that they would have some liability because of her actions. Anyways, defendant Allen's attorneys believe, but are not certain, that Dr. Walla currently resides, and I redacted the address, even though there are versions of it out there that it's available. Dr. Walla also confirmed during prior testimony that she resided in the state of Illinois. Therefore, defendant Allen desires to secure the appearance and testimony of Dr. Walla, an out-of-state witness, through the process provided by the Indiana Code. Defendant Allen believes that Dr. Walla is a material witness in this case for the following reasons. A. Dr. Walla was assigned to Richard Allen as his treating psychologist while he was incarcerated at Westville Correctional Facility for over 1 year. Dr. Walla met with Richard Allen on numerous occasions during his stay at Westville, nearly all of which were intended to address and monitor the state of Richard Allen's mental health. Nearly all of the communications between Dr. Walla and defendant Allen occurred in confidential and privileged therapeutic sessions. And those are in quotes because those are probably the words that she used or the state is using, but they have other ideas about that. It's probably not confidential or therapeutic. The state intends to introduce as evidence in this trial incriminating statements made by Richard Allen while incarcerated at Westville Correctional Facility. The defendant intends to prove that incriminating statements made by defendant Allen were involuntary and resulted from the conditions surrounding his incarceration, which include this woman and her deciding to just give him Halidol, which can cause hallucinations and make you even more mental if you have mental health issues. So Dr. Walla was in the position such that her medical opinion regarding her psychiatric condition is relevant to these proceedings, absolutely relevant. The defense believes that Dr. Walla's testimony will require approximately 2 full days and specifically requests that this honorable court order Dr. Walla to appear on Monday, November 11th and Tuesday, November 12th to testify at this trial. Defendant Allen seeks a certificate of appearance from this court acknowledging Dr. Walla's materiality in this cause and specifying the number of days Dr. Walla will be required to attend the trial in this cause. Defendant Allen further requests that said order be certified under the seal of this court. Defendant Allen then intends to present such order to a court of record in Cook County, Illinois, the county and state in which Dr. Walla is believed to reside. Defendant Allen intends to utilize this process to secure Dr. Walla's appearance at the trial in this cause, and Defendant Allen intends to tender a sum for expenses equal to the amount provided by under the same some more Indiana code to reimburse Dr. Walla for her attendance at the trial, all fees which should be charged upon Carroll County, Indiana, where the prosecution is pending. So he's asking, make her come. She's obviously material in this case because she was treating him. So we need her to get here. We need her on these dates, such and such dates. It's going to take 2 full days. Make her aware of that, please. And also, let's pay her for her time and reimburse her for her travels. So that's pretty much it. Probably pretty standard stuff there. Nothing really jumps out at me. But here we have, let's move on to today's filings. These were from the state, and they have a couple motions in limine that they filed while they were in the middle of jury selection. So comes now the state of Indiana by prosecutor Nicholas M. McClelland for the 74th Judicial Circuit and respectfully requests that the court enter an order prohibiting the admission or reference to the Indiana Protection and Advocacy Services Commission versus IDOC lawsuit and any findings by that court or the IPASS settlement. I don't know if they'd call it IDOC and IPASS, but I'm going to. So, all right. So the IPASS settlement, as referred to by defense counsel during hearing on motion to suppress and in various depositions for the reason that said lawsuit or settlement is not relevant to this cause. In support of the motion, the state would show the court the following. Number one, that the IPASS lawsuit and settlement agreement has been used as an exhibit by the defense and has been referenced in questioning at prior suppression hearing and in depositions. And just before we read much further, let me just explain. So this IPASS, Indiana Protection and Advocacy Services Commission, on behalf of its clients, and there's some people who are the plaintiffs, and then it's versus the commissioner of the Indiana Department of Corrections. So there was this lawsuit. This was back in 2012, okay, and it was a bench trial. I don't know the actual outcome or the settlement or anything like that. I believe there was a settlement, um, but or sorry, my screen's going out. I believe there was a settlement, um, or maybe the screen keeps going out. Sorry. All right, so I'm not going to read through it. It is 37 pages, but I perused it, and it's basically talking about the whole Indiana Department of Corrections. It lays out, stuff about segregation and putting people in segregation, especially when there's mental health issues at hand. So that's what this whole lawsuit is about. So and they list all of the different facilities that ISP is in charge of, or IDOC, and that includes the Wabash Valley where he was and the Westville Correctional Facility also where he was. It talks about the number of beds. It goes into like all the details about the different things that prisoners have to go through, or like their different the different things that they are allowed. So like correctional programming, whatever. We're not going to read through all this. But you see, it talks about mental health issues, and so there's this whole, scale of this axis, which gives you they create this is from the Diagnostic and Statistical Manual, the fourth edition. Those are the DSM-4, and it basically rates people their mental health conditions on a scale with the axis 1 through 5, and it has to do with. There was a good quote that I wanted to read. If I can find it. Um, yeah, so mentally ill prisoners in segregation, there was a survey done, and it basically came up with there are 5,867 prisoners that were diagnosed as mentally ill, which is a 22% rate of the IDOC prisoner population. So I mean, it's not huge, but it's big. That's a lot. That's 5,000, over 5,000 people. Um, Here was some more. We're not going over this because there was so much, but I just thought it was interesting reading through some of this. So, based on the extensive evidence presented in this case, this IDOC case, the court finds that there are three ways in which segregation is harmful to prisoners with serious mental illness. The first is the lack of social interaction, such as the isolation itself, creates problems. The second is that the isolation involves significant sensory deprivation. The third is that the enforced idleness, permitting no activities or distractions. These factors can exacerbate the prisoner's symptoms of serious mental illness. This condition is known as decompensation, an exacerbation or worsening of symptoms and illness. Decompensation can be manifested by a prisoner experiencing auditory or visual hallucinations, sleep disturbance, memory problems, anxiety, paranoia, depression, eating problems, or engaging in self injury or self deletion. And we know this because these are issues that Richard Allen was having, hallucinations, um, uh, just problems focusing. Like he was so out of it half the time. He was paranoid, depressed. He was eating his own feces. He was running into the wall and slamming his head into the wall. So these are all issues that the Department of Corrections knows happens. And they obviously have, extensive research in this and whatnot. Um, especially after this particular case that happened. Was I gonna read this? Yeah, this where additionally, these effects are known. So this decompensation is known by the IDOC through the private settlement agreement, wherein the IDOC agreed that prisoners with Axis 1 diagnoses would not be placed in a special confinement unit, and to which the commissioner of the IDOC stated these offenders may have been diagnosed with a mental disorder that is worsened by confinement in secure confinement unit. In these cases, it is in the best interests of the department to attempt to obtain mental health treatment for these offenders rather than simply placing them in long term disciplinary segregation or department wide administrative segregation unit. Do you see why the defense would want this in? It's very, very good. It's well written. I'm not going to read through all of it. Obviously, that's where I'm going to stop. But so, yeah, you can see through this particular lawsuit that happened in 2012 that they're fully well aware of the issues surrounding pa- uh, putting inmates with mental health conditions in solitary confinement. So let's get back to the motion from Nick McLeland. He says that this is, he doesn't want any of that to come in. So, in support of this motion, the state would show the court the following. In the IPAS lawsuit and settlement agreement, um, the it has been used as an exhibit by the defense. So they've already added this this case in their defense as an exhibit, and has been referenced in questioning at prior suppression hearing and in depositions, probably because there are some good little portions that they can quote and throw back at the IDOC and say, "Hey, you guys knew all along that you shouldn't be putting patients with mental health conditions in seg- segregation for that long." Anyways, moving on. Number two, that to the state's knowledge, the settlement agreement was extended to 1 year after the dismissal of Mast versus Indiana Department of Corrections District Court for the Southern District of Indiana, which occurred on July 23rd, 2019. Therefore, the IPASS settlement was scheduled to terminate on or about July 2020. So he's being disingenuous here because it was actually terminated, I believe, because of the issues. So the settlement was actually, they're saying it was scheduled to terminate. I think it I think that's a lie. Um I think it was terminated because of the issues that were going on. Number three, that Richard Allen did not enter IDOC until November 22nd, 2022, and was in safekeeper status while housed pursuant to the court's order. That the defense has used the IPASS settlement and other documents from the lawsuit as exhibits to examine or impeach witnesses who were not a party of the lawsuit, were not employed by IDOC, and do not have a responsibility in creating IDOC policy in response to the lawsuit. Number five, that the lawsuit, but they still should be required to follow IDOC policy. So if they're an employer or an employee with IDOC, I would think that they would be able to speak to some of that. Anyways, the lawsuit against IDOC and IPASS settlement is not relevant to the question of the defendant's guilt and should be excluded under Indiana Rule 401. That the mere mention of the lawsuit would be misleading and confusing to the jury and should therefore be excluded under Indiana Rule 403. In addition, the spirit of multiple other rules of evidence, specifically 407 and 408 and 409, indicate that judicial proceedings and settlements on extraneous matters are generally disfavored. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McLeland, respectfully requests this court to grant the following relief: order the defendant, his counsel, and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to the IPASS lawsuit, court findings, or settlement agreement, without first obtaining permission of the court outside the presence of and hearing of the jury. And B, to further order said persons to make no reference to the fact that this motion has been filed and granted. So we don't even want them to know that we don't want them to know what that means. All right, so he doesn't want that whole settlement, nothing talking about that, to come into trial, but I don't know. I don't know if uh, I don't know how they would get it in. How are they going to get it in is the issue. If it's an exhibit, fine, but who's going to authenticate it and make it, and talk about it? That's the only issue. I'm sure they've got that figured out. Anyways, all right, so the state's motion in limine regarding composite sketches. Do you guys remember our composite sketches? Hold on one second. I had it open and now it's gone. One second. All right, so here I have, this is the sketch one, which was done by Sarah Carbow. If you look at the screen here, sketch one was the older gentleman. She stated that she saw a man walking west away from Monon High Bridge while she was driving by, described a blue colored jacket and blue jeans. She was misquoted as describing him as muddy and bloody. She never said the word bloody. And she also provided the description for the sketch in July of 2017. So that is Sarah Carbow's sketch. The second sketch is the Betsy Blair sketch. And this, she was walking on the trail on February 13th. She saw this man. She described a white male wearing blue jeans and a blue jean jacket. She saw a man standing on the platform from about 50 feet away. She was not driving. Remember, keep in mind that Sarah Carbaugh was driving. She was driving by. So, I don't know how well she could have seen him, but that's her sketch. And so this woman, she was standing near him 50 feet away. She provided this description for sketch 2, which was released on April 2019. But the order in which they came out and then the way that once they came out, the law enforcement was saying that they're the same person, which clearly they're not. So here is a image on the screen that I have. This is so both sketches side by side, sketch 1 and 2, and you can see Richard Allen doesn't look like any of them in my opinion. And then you got Brad Holder, who was another potential suspect. Then you've got this is Ron Logan, Patrick Westphal, Jesse Messer, uh, Keegan Klein, Elvis Fields, and I think that's Rod Abrams. I think. Yeah. So, oh wait, it is Abrams. Ned Smith is the other one that we don't have a picture of him. So, as you can see from my, this was from a presentation I put together of the who's who of Delphi, which is on my playlist. If you are curious, you want to go back and see who all these individuals are. I go into like a deep dive on everybody involved in the case or all these names. But, anyways, so these three, Westville, Holder, and Messer, are from the Delphi Vinlander crew. And the recruits over here were Elvis Field, Rod Abrams, and Ned Smith. And obviously, here you've got Messer, who's the recruiter. So he's the connection between the two different groups. Because these guys, remember, they're all from Rushville, and these guys are closer to the Delphi area. And that I think Rushville is like an hour and a half or something away. I'm not really sure. And then obviously you've got this is Logan Holder, the son of Brad Holder, and he was dating Abby, who was best friends with Libby, and that hence they were out together. So that's the connection. The connection that Judge Gull says doesn't exist. There's no nexus there, but you can see there is. So I wanted to go over that and show you the sketches one more time just because get them fresh in your mind. So comes now the state of Indiana by prosecutor Nicholas M. McClellan for the 74th Judicial Circuit and respectfully request that the court enter an order prohibiting the omission or reference to composite sketches prepared by any sketch artist for the investigation of the homicides of Abigail Williams and Liberty German for the reason that a composite sketch is not relevant. Admission would result in undue prejudice, confuse or mislead the jury, or is impermissible hearsay. How is it hearsay when you are the guys that went around and was like, this is the guy that we're looking for? Call in all your tips. We want all your tips about these people. And the witnesses who participated in the preparation of composite sketches. So they don't even want the witnesses there to talk about who they saw. Will not be presented at the state for the purpose of in-court identification of the defendant. In support of this motion, the state would show the court the following. Number one, the composite sketches prepared were intended as an investigative tool to generate leads to identify a suspect, and in fact, those sketches were not related to the identification of Richard Allen as a suspect. Therefore, the sketches would not be relevant under Indiana Rule of Evidence 401. Bull baloney. Because it's part of your investigation. It should be relevant. You guys relied on these sketches for years, and the public was given those images for years, and you guys are now taking it back saying, "Oh, just kidding. Not these sketches," because he doesn't look anything like the guy that we have in prison for it. Number two, that the witnesses who assisted in the preparation of composite sketches of the bridge guy would testify that they did not see the person depicted in their sketch for a sufficient length of time to allow them to positively identify the defendant. Therefore, under Indiana Rules of Evidence 401, the composite sketches are not relevant. Number three, that if the court were to consider the composite sketches to be relevant, the probative value is substantially outweighed by the unfair prejudice, confusing the issues, and misleading the jury. How is it confusing the issues and misleading the jury when that is what that is how the investigation started, and therefore should be excluded under Indiana Rules of Evidence 403. A composite sketch reflects the police artist's interpretation of someone else's description based on the artist's synthesis of an infinite variety of facial features and configurations. Creating a composite sketch carries the potential suggestiveness of having a police artist interpret and possibly influence the perceptions of the witness. So you're basically admitting that your sketches are garbage and they don't even matter, which we knew that, but especially because you guys just keep lying to us, to the public. That the composite sketches would be hearsay or double hearsay under Indiana Rules of Evidence 803, in that the sketch is an out of court statement and a subjective rendering by one person under the subjective description by another person or witness, and does not fall within a recognized exception. Number five, it is the state's belief that the defense intends to use composite sketches from the investigation as demonstrative evidence and for impeachment purposes. That the witnesses who participated in the preparation of composite sketches are not being called to provide in court identification of the accused. Furthermore, no composite sketch was instrumental in identifying Richard Allen as a suspect. Well, they should be allowed to provide in court identification or say, no, that's not the guy I saw. They should be able to say that on the stand. Number six, that the prejudicial effect of composite sketches far outweighs the probative value for in-court identification of the accused and would likewise be inappropriately used to impeach a witness. So they don't want it to just impeach the people, the witnesses. They think that the defense is just going to use it to impeach the witnesses, when in fact they're trying to point out the fact that the investigation was never pointing at Richard Allen in the beginning. That's why these sketches are important and should come in. Number seven, the Indiana courts have not addressed, and the fact that there's two individuals, also that's important in this case because Richard Allen's one person. And it seems like multiple people were viewed at this time, were seen at this time by witnesses, and neither of those people were Richard Allen. So that is important and it should be relevant. Um, Prejudicial effect of the composite sketches far outweighs the probative value for in-court identification of the accused and would likewise be inappropriately used to impeach a witness who is not presented before the jury to provide in-court identification of the accused. Number seven, the Indiana courts have not addressed this issue or use of composite sketches. Indiana courts have excluded composite sketches that resulted from the use of victim/witness hypnosis. We're not talking about hypnosis. Other Indiana cases discuss or mention the existence of a composite sketch in the course of an investigation leading to probable cause to arrest, but no analysis of their use as evidence to impeach witness testimony. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McClellan, respectfully requests this court to grant the following relief: order the defendant, his counsel, and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to composite sketches without first obtaining permission from the court, and B, to further order said persons to make no reference to the fact that this motion has been filed. Again, we don't want them to know that we don't want them to know. So why on earth are you so against these composite sketches now, which you were putting all over the news, all over the media for years? These were our guys. And then at some point it was some kind of mix of the two to equal your one, which was, it made absolutely no sense. These are obviously two different individuals, one with facial hair, one without, one with a hat, obviously, and hair, straight hair sticking out, and one with, kind of looks curly hair. He looks much younger, the second sketch. So obviously they are not the same person in my brain, but okay. That's whatever. The state just really has a bad case. They have bad facts because the facts are not on their side when it comes to their interpretation of what happened. So let's talk now a little bit about what happened at jury selection. So at the end of yesterday, at the end of Monday, there were uh what was it? I want to say they had 12. They had 12 and then it dropped down to 11. So the three jurors had to be bounced, I guess. There was childcare issues, a professor with diabetes issues, and somebody else they were working on trying to confirm why they got bounced. But anyway, so they started the day with 11. They're trying to get 16, 12 plus four alternates. So um, that was the start of the day. They started out with 11. They now have their 12 at the end of today, the 15th. Jury selection is complete in the Delphi trial, and there are 12 jurors and four alternates. The jurors will be sequestered for about a month. Opening statements are scheduled to begin on Friday when the proceedings shift to Carroll County. So, um, this is Kit Hanley TV. I don't know what station she's with, but she's local and she is reporting on this. So she says their team will be there. She says tomorrow, so Wednesday, tomorrow is an off day before an additional hearing on Thursday in Allen County concerning widely circulated composite sketches in this case. The state filed a motion asking for the sketches to be excluded from the trial. So on Thursday, Wednesday's an off day. There's nothing Wednesday. Thursday, they are going to have a hearing. They're going to talk about the composite sketches and figure out if they're going to come into trial or not. And then Friday will be opening opening statements. But there's more that came out today in the hearing, and this is breaking news. This was from an Angela Ganote or Ganote. I don't know how to say her name, but she says breaking. Richard Allen's defense attorneys say hair found in Abby Williams' hand does not match Richard Allen's DNA. That has never been made public before. So this is brand new information. Um, oh, next page, sorry. So what did Sleuthy Goosey said here, posting a picture instead of retweeting because it might at some point disappear. So that was a great idea that she did that. She says there was a hair found in Abby's hand that does not match Richard Allen. So here's the full tweet from Angela Ganote or Ganote. I don't know. Sorry, not. She's probably local. I have no idea. All right. So breaking: Richard Allen's defense attorneys say hair found in Abby's hand does not match Richard Allen's DNA. That has never been made public before, but during our interview with the sheriff days after the homicide, he told me and this Ray person on live TV that they had DNA. So they're claiming that there is DNA evidence in this case. They have this hair in Abby's hand, and it's not Richard Allen's. And look what happened after this conversation with law enforcement. So the sheriff tells them we have DNA. And then law enforcement then asked us to remove that information from our website, saying the sheriff was speaking without full knowledge. So now what? They don't have DNA? Or what? This is some kind of PR stunt now to cover up the fact that they said that there was hair in the hand. This was 2017 days after the homicide. Check Fox 59 for new and breaking details all day. So at some point after the homicide, they say, take that off of your website because he was speaking out of turn. DNA in Abby's hand that doesn't match Richard Allen's. That's big. That's huge. This is breaking news. I mean, this is huge news. And we are persecuting and prosecuting Richard Allen for what? How did he even get picked to be their guy? This is the question. And it's very concerning to all of us, and why none of the evidence is adding up in this case. It's leading to somebody else did this, somebody's else did this. I believe there were multiple people involved. And I do think there was an Odinist relation somehow to those homicides, and real evil is out there. There's a lot of evil, um, should I say, secret societies and clubs that would hurt young girls, minors, children. This is going on everywhere. We have the number one country for children disappearing and being taken from one place to another. I can't say that word, but you know what I mean. Being taken from taken from their parents and their lives and brought somewhere else to be mistreated. These things happen all the time, and why we're not looking at it from that angle or trying to ignore the real evils, and instead we're like persecuting the attorneys in this case and Richard Allen, because remember, the attorneys have taken so much heat from Judge Gull regarding their Odinist, um, the line of Odinism that they want to go down. She does not want it, as you can see, which makes me believe that this might even have law enforcement ties to it, perhaps. If not a law enforcement officer or someone high up in government involved, then maybe, just maybe, they are somehow covering for someone that they know or love that might be involved in these kinds of secret groups that do these horrible things. So I don't know. I don't really know what the answer is, but there's definitely nefarious things afoot in Delphi that are happening. And Judge Gull and her cohorts all just want to hide it. And again, we have no camera, no audio of the court. So we are relying solely on people who are attending. So hopefully we get some good reporting. There have been good, honest YouTubers that are going to these and that have gone to the hearings so far and will be attending trial, and hopefully we can get some good reporting back from them, which I think we will. Andrea Burkhart is one that I believe she's going to be going every day, and she'll be reporting, and there's so many others. I can't say them all, but I will make sure to keep you guys in the loop. This is crazy case, and it just gets crazier the deeper we get. So please don't forget to hit that like button. Thank you guys so much for watching. I appreciate you in so many ways. Thank you for your participation and just for watching and being observant of what's going on in our communities out there. So take care, guys. I will see you in the next one. Bye.